Welcome to Business Talk with Meghan McNulty, the podcast that takes you behind the scenes of business success and reveals the strategies, insights, and stories that drive these professionals to thrive in the ever-evolving world of business. Whether you're an established entrepreneur, a seasoned business owner, or simply fascinated by the world of commerce, this podcast is your front row seat to learn from the best. Each episode, Meghan will bring you engaging interviews with professionals from diverse industries who will share their triumphs, lessons learned, and the insights they've gained along the way. Hi, Alison. How are you?
I'm doing well. How are you doing?
Good. So I'd like to introduce you to everybody. You're a trust litigation attorney, and I'm so happy you're going to allow me to ask you some questions about trust litigation today.
You run a great podcast, so I'm
Thank you.
happy to be included.
So I know your main focus is litigation, but you also do other things. So do you want to kind of share what exactly your practice specializes in?
So we just do trust litigation and then probate. We deal a lot with a lot of nonprofits too, because nonprofits are often beneficiaries of trusts. So we will work with them. Sometimes we're involved directly in the litigation, but a lot of times the nonprofit may actually be a backseat beneficiary. So we're just making sure that the litigation is not harming their financial interests as well.
Let's just say someone's getting into trust litigation, right? So they're either a beneficiary or one of their family members is a beneficiary. What is like the process? When does this come about?
Normally, trust litigation starts when someone passes away. It doesn't always start then. Sometimes it actually starts when the person who created the trustor, it becomes incapacitated. Or it can happen when there's bigger businesses that are parts of trusts. Trusts are essentially an entity similar to a corporation. So it is something that is created sometimes for tax benefit and sometimes for providing assets downstream after someone passes. So anything that involves that trust, we are able to step in. So we have a team of people that do business litigation as part of our trust litigation practice. But there's a lot of times, anytime trusts are involved, it happens within the probate court. And the probate court, there's a stack of books over in the corner on my desk. That's just the probate code. And the probate code is very different than a lot of the other laws. So anything that involves a trust or involves the death of someone in which there's a dispute, that's when we step in.
Basically, I think I would like to reframe so people understand, like, if you go to probate court, it's completely different. It's you're going to court with attorneys, and this is specifically for trusts or when someone passes away and you're trying to get access to their assets, correct?
Yes. So when I pass away, if I'm owning something, anything that's over a certain threshold amount, it's about $186,000 right now. It changes each year. But in the state of California, I pass away and I have anything that's in my name at the time of my death, it has to have some mechanism to move to the next person, the next beneficiary, or the next person down the line. If I can either do it by taking all of my assets, putting my home, putting my car, putting stocks, putting jewelry into a trust and actually retitling everything into that trust, or I can just pass with it. But because I no longer am alive, the court sometimes, the probate court has to get involved to then help transition those assets or transition the property to the next person downstream. Because once you die, you can't take anything to the grave with you, including title.
Let's just say we have someone's passed away and we have a trust, and now the beneficiaries of the trust are fighting one another. At this time, would they come seek out a trust litigation attorney to help resolve the dispute?
Yeah. So if you have a trust, the first thing that happens after someone passes away is there's someone who's usually appointed in the trust document, or prior to the death, someone is appointed as trustee. After someone passes, that trustee has to give notice of their passing and notice of the trust being administered. And that has to be done within 60 days of someone's death. A lot of times that each beneficiary, nonprofits, it could be a school, it can be the American Red Cross, or it can be children. And they actually get a document, it's called a Notice of Trust Administration, and the trust is attached to it. And at that point, if they have any questions, that's when they immediately call us as beneficiaries, or before then, if they know there's going to be some conflicts, they get us involved right away to start corralling all of the documents and putting all the pieces together to make sure that the administration of the trust and the assets can transfer from one generation to the next easily.
If beneficiaries start fighting, and trust litigation starts and you're now in court with the beneficiaries, what's the process? How long does it normally take to get through a trust litigation case?
So from start to finish, right now, it can take years. We have one case that we filed the litigation in 2018.
Wow.
We just finished an 8-month-long trial, and we're now probably waiting for the appeal to hit. So this case will probably take 10 years. That's abnormal, but litigation, depending on how big the assets are and how complex the issues are, if you're thinking about hundreds of millions of dollars of assets and different ownership interest and different beneficiaries, it becomes really complex. But if you have a middle-class family, they own one house, the house is in a trust, it can be a lot easier and seamless. So it can take up to years, but I've also had cases that we've been able to step in, the attorneys are in there, or we're working with the trustees, and we're able to resolve the case within a couple of months. But again, is just like everyone who has family, sometimes the challenges are not necessarily logical, they are emotional. And so when it's emotional, I say that there's the business judgment lane, which is the fast lane in resolution. And then there's the emotional lane, which is the slow lane. And so the emotional lane, sometimes we have to go off every exit ramp. We have to take every possible detour, and it'll take a lot longer. But if we're living in the business judgment lane, we can push through and resolve the case pretty quickly.
Would you say, let's just say I was a beneficiary of a trust with one of my sisters, and we started fighting with each other over it. Is there any consequences to me bringing litigation against this trust and whatever potentially my parents put in there and their wishes?
I think in the bigger picture is when you're looking at a trust document, the question is whether or not the people who wrote that trust document. So in regards to your parents, if your sister, the bad sister, the bad sibling, comes along and actually manipulated your parents into making them the sole beneficiary, or manipulated them into signing a deed or transferring assets over to quote unquote make them eligible for Medi-Cal, Medicare as people age, then that's when the actual trust document is being questioned. The validity of it is being questioned. And that's a dispute there so that's one aspect. So it's questioning the actual trust document, whether or not it's good, whether or not it's valid. The other side of the equation is whether or not, let's say you and your sister are co-trustees, you're both trustees, you're both responsible for following through with your parents' wishes, making sure that a certain amount of money goes to a nonprofit, a certain amount of money goes to their favorite university or their favorite college football team or whatever they want, and then to you and your sister. If you are both co-trustees and your sister's not giving you access to the bank accounts, she's not telling you what she's doing, she's hiding things from you, that's another type of trust dispute. And where you're both trustees and you have equal access. Another type of trust dispute is where, if let's say your sister is the sole trustee and she's not giving you your distribution, and she's just pocketing that herself, that's an accounting issue. And that means that she's actually not fulfilling her duties as trustee. And you have, as a beneficiary, a right to certain pieces of information and a right to an accounting and a right to know that she's actually distributing the assets and doing what she's supposed to do. So the things about trust and being a trustee and the things about money and death is that it becomes really complicated when people start lining their own pockets or acting in their own self-interest or acting emotionally, because they have to really be following the trust document. They've got to be looking at what the trust tells them they can and cannot do and complying with that.
Let's say, okay, so let's go back to scenario where my sister and I are beneficiaries of a trust, and let's just say she's the trustee and the beneficiary, and I'm just the beneficiary, and she's not really telling me, you know, what's happening. Like, is she selling the house? Is she not? Is she like required to do all that? Is she required to, like you just said, that you're supposed to give an accounting if we were co-trustees together, but if I'm not a trustee and just a beneficiary, is she still required to give me all that information as she's going through the trust administration process?
For a basic rule of thumb, yes. As a beneficiary of a trust, you have a right to an accounting, you have a right to clarity. At certain points, you become a contingent beneficiary. So let's say you have two parents. Dad passes away, mom is still alive, but maybe she's in a memory care facility. So she's no longer able to administer the trust. She cannot be trustee anymore. So now your sister takes over. And you two are, let's say you're the next beneficiaries after your mom passes. You are what's called contingent beneficiaries. If there's still money after your mom passes away, then you get the assets. As a contingent beneficiary, you have little less right to get access to information, but you still have a right to a trustee's report. You still have a right to information. It's only when
Okay.
you become a full beneficiary, you have the full right to an accounting. So it's sort of contingent as to what your role is. Now, in regards to what your sister has the obligation to do, she has an obligation. We're really beating up on your sister, but that's okay. She's just bad sister, bad trustee. She has some very specific obligations, but they're all outlined in the trust. And when the trust doesn't speak to it, then we default back to the probate code. So the obligations are very clear within the trust as to when distribution should be made. Maybe your parents have a vacation home and their wish was for it to be the family vacation home, and it has to be used for family vacations for the next 10 years. And then only after 10 years will it be then sold and the cash distributed. So it's really looking back at the trust document to lay the rules of the road. Those are the rules that are supposed to be followed.
Okay, makes sense. Is it expensive to go through a trust litigation?
It is sometimes, and I say this to a lot of potential clients that come in, that the only people that win in a trust litigation are the attorneys. And it's because it could cost hundreds of thousands of dollars to litigate something for a trust that's worth $800,000. So if you've got a home in Orange County, that property could be worth anywhere from 600 up to multiple millions of dollars. And it's going to cost potentially $10,000, $20,000 just to start the litigation, to get the petition started.
Okay.
So in probate, it's a little different. So normally you have your complaint, which is what the lawsuit is. You sue someone, you've got a complaint. In probate, it's a petition. And when you file a petition in court, as the petitioner or as the trustee or the beneficiary, you actually are providing the court with a verification under penalty of perjury that all the information in the document is true. And you actually provide the court your evidence to show it. So you've now filed your testimony into court to start the process, to start the whole trust litigation. And that's expensive because you're going to have to do a lot of fact finding. The attorneys are going to have to now verify all the information to be true. And it's very costly to do. But when we're talking about millions of dollars of inheritance or millions of dollars of assets, it becomes necessary to take those steps.
Right.
We've had cases that will cost 10% of the trust, but the trust is worth $10 million. We've had cases that cost 50% of the trust, but the trust is worth $500,000. Our firm particularly is very keen on giving the clients a really hard cost benefit analysis of, are you going to fight your sibling because you just want to do what's right and you want to correct the wrong and you want to honor mom and dad's wishes or grandma and grandpa's wishes or your great aunt's wishes? Or are you in this for the money? Because again, it's the business judgment lane or the emotional lane. And some people, they're okay with living in the emotional lane and would rather run all the assets out to right the wrong, versus some will make some really a business judgment decision, and maybe they'll back out of the case or they'll go to an early settlement and take less than they know they deserve. They know what's right, but then they're done with it.
Right.
So it's for each client and each person, it's a very different set of circumstances.
Well, my question with that now is, can we go to charity? So a lot of people will make charities a beneficiary of their trust. And my question for you is, do you have any advice for people that are charitably minded that do want to donate to charities, and like how they should go about doing it to avoid potential litigation down the road with the trust, and maybe the charities versus the siblings, or charities versus the heirs at law? Any advice on that?
So my first advice this is for charities and for anybody with any assets, is to go to a really good financial planner like Meghan McNulty. And I'm not being paid to say this, but to get a really good estate planning attorney that is not just going to be running quick trusts, almost the level of LegalZoom, but actually really quality trust documents and having a full financial plan as part of it. When you have a certain financial choices that someone makes so that they give money to a charity through like a charitable remainder trust or a charitable lead trust, and that's where people are giving money eventually to the nonprofit, or they give money now and some money goes to their beneficiaries. There's all different tax consequences and benefits, and this is your world. Those types of vehicles actually do guarantee the trust to pay out the nonprofit a lot easier, because now the money is outside of the trust, or the money is within an annuity, or it's separate. So it actually guarantees that payout at some point. But to me, the biggest thing for nonprofits to be aware is when they become a beneficiary of a trust, it's knowing what to do when documents come. So let me give you an example. So we had a case with a school in Orange County, and it's an amazing school for kids with dyslexia and dysgraphia. And they received this $6.5 million gift as part of this gentleman's estate plan. And the children of this gentleman were very unhappy because they wanted that money for themselves. And so the school came to us and we saw the documents, we started analyzing it and realized right away that this was very clearly a gift. The guy had capacity, and his kids were actually getting $12 million, $15 million each from a generation skipping trust from grandma and grandpa. They just wanted an extra $6 million to go into their pocket because 12, 15 million wasn't enough. So in most cases, most nonprofits will just kind of throw their hands up and say, all right, we don't have time for this, we don't have money to pay for an attorney to deal with this stuff. We'll just take what we can. And if they're willing to offer us a couple $100,000, we'll walk away. Well, that was the initial offer. They were offered a couple $100,000, but they hired us. We started looking through it. And what it ended up being is that we were able to completely flip it so that the school got they're almost 6.5 million, and the kids got 100,000. It was because they trusted us to do our job. And a lot of times nonprofits it'll be so mired in the everyday of doing the good work that they do that they won't utilize the resources that are available in the community to actually effectuate someone's true gift to them.
Right.
And being able to obtain, and you get, let's say you get a notice, and it's called a Breslin notice as a nonprofit. You get a document saying that there's a trust dispute and there's going to be a mediation or court-ordered mediation. And the nonprofit sits there and looks at it and goes, we don't know what to do with this document, and then throws it into the filing pile. That's when they lose money. That decision is the biggest loss. Whereas if they call a law firm, a trust litigation firm, to now represent them, they are now guaranteeing that they're going to get some amount of money from this, from the estate. And really, they're just trying to effectuate the wishes. So that's why I always say for nonprofits, it's awesome to have an attorney on your board. It's awesome to have a CPA on your board. It's awesome to have financial advisors on your board, people that are knowledgeable within this area to really invest and protect your long-term plan giving as a piece of the dynamic so that the nonprofit can ensure their longevity.
In terms of when people are like structuring their trust to give to charities or nonprofits, any like specific things you've seen work really well or that have been a problem that comes up in these trust litigations? Or
yes, one big problem that I've seen pop up is people not naming the right charity.
Right. Oh yeah.
So there's like ASPCA and SSPCA or various animal charities. There's different charities that are out there. Or let's say a trust was made in the 1980s and the nonprofit merged and it no longer exists. What ends up happening in those circumstances is that because people are not going back to their estate planning attorney every 3 to 5 years, they don't fix those things. And what happens is the trustee now has to go to probate court, hire a trust litigation attorney to go to probate court to ask the court for instructions, to basically say to the court, look, the trust says it's supposed to go to MSPCA, but I think they meant SSPCA or some other nonprofit. Now we have to kind of go back and forth and have the court approve this process. That can cost, just doing that, if there's nobody contesting it, that can cost $20,000.
Right.
Just off the bat.
Okay.
But as we age, we don't take that time to go back to the estate planning attorney. As we age, we don't want to spend the $2,000 for the estate planning attorney to do a review. Unfortunately, it's sort of penny wise and pound stupid because we're so worried about the pennies today that we don't realize that, again, who's going to make the money? The attorneys are going to make the money because it's going to cost a lot of time and a lot of energy to get the court to fix those things early on.
Okay, that's very helpful. Do you have any advice for families that are going into trust litigation on what they should do to protect themselves?
It goes back to the question of why are we here? What is the fight about? I have been in mediations, I have been in trials where somebody is talking about the pink bike that their sister got brand new, and they're a brother, and they had to have the hand-me-down pink bike from their sister. And that's because mom and dad loved you more, and I always got the short end of the stick, and I deserve this. A lot of conversations with clients or even opposing parties when I'm taking depositions is, I was there for mom and dad. I was changing their diaper. I was in their house. I was taking care of them. I deserve this. And I have seen more families blown up where they're no longer speaking to each other because they have this sense of deserving and what's right and what's wrong. And I look at trust litigation as really a first world problem. It's a problem for the wealthy. It's a problem for people with means. And it's really in perspective Do you want to invest the next year, year and a half, maybe 2 years of your life battling your sibling because they did you dirty and they manipulated mom to change the trust and get the benefit? Are you doing it because this was what mom wanted and what mom wanted, and you're willing to die on this mountain and you're willing to fight it? Either way, if it's an emotional decision or if it's a financial decision, we're there to support it. But what I like to always do and always have with our clients are really open conversations of, all right, this is what it's going to cost and this is where we're going. But I understand there is off ramps. There are ways to exit this program. There are ways to get out of this. And it's not going to be as much money as you want. It's not going to be what you think you deserve. And it's not always going to be fair and equitable. But you have to do what is in your best interest. I've had other clients that to them, it doesn't matter. They will fight tooth and nail to make sure what mom and dad wanted or what grandma and grandpa wanted is really fulfilled, that they really wanted $1 million to go to the American Red Cross because it saved grandpa's life with the blood bank and
Right.
being able to provide, and it saved him, and that's important to him. People really have to understand and be aware and conscientious of the reason why they're litigating, because it is a marathon. It is an endurance race where you have to constantly be in check of why you're here. It's hard, and we get that. I understand that anybody who knocks on our door, anybody who's calling us on the phone, it's not because something happy happened. It's not because something is going well. We are here to fight because, again, somebody did you dirty or somebody's doing something bad and we need to fix it and right the ship.
So this might be a curveball, but you just made me think of, what about the fact that we hear about all these celebrities who apparently maybe had an estate plan, but they're always in litigation for like ever when they die? Do you have any insights on that?
I find the celebrity world fascinating for that, because you have all of these, you've got press people, you've got your PR team, you've got your attorneys that are helping you with contracts. But what happens in these family disputes or these trust disputes for celebrities is a lot of times there's multiple children from different marriages, because
Okay.
celebrity, it's not an easy life to be living. And so you have those aspects of the concept of community property and what's separate property and what's yours. The other thing that's really challenging is we live in California. The state of California has a very different set of laws for inheritance and intestate, and most states, or many states, especially in the South, you don't actually need a trust. You just need a will, and it's very quick and easy to go through probate and distribute assets through a will. In California, you need a trust because it is truly probate court avoidance. You're avoiding the court if you have a trust. But what if you have an asset in Chicago, or you have an asset in Texas, or you have an asset in Puerto Rico?
Right.
In another state, or we've had cases with assets on Native American reservations. That's a separate nation. And you have to abide with the tribal laws there, but the trust in California isn't necessarily going to have hold title over that property because of different concerns. They're titled in that state. So a lot of times with celebrities, sometimes they've got really messy family lives on the backside, which is really great for TMZ and fabulous to watch on People and entertaining. But there's also the legal side of who owns what state has jurisdiction, and was the trust the subject of undue influence? I mean, so if you look at someone like Aretha Franklin, what an amazing, powerful woman, and yet she had wills tucked into her couch bed and into the cushions between her couch. And there's a whole litigation about her assets And who owns the rights to her songs? The issue that I see with a lot of celebrities is they didn't actually have people around them that they could trust. They didn't have a good financial advisor. They didn't have a good estate planning attorney for each state that they owned assets. They didn't have a good plan in place because maybe it's because of the stardom, and maybe it's because their lives are really messy and they're bounced around from one stage to the next. But there's a lack of planning and a realization that
Right.
do not escape this life living. We escape it through death. And that's hard for some people to accept.
Right, and deal with. And good point to the fact that yes, not all the assets might be in California. So that's something that people should consider because every state's different. Even though we have federal law too, but every state, if the assets in Arizona or Florida or New York, it's going to be different potentially.
And I mean, I've had cases where we've had Washington Mutual as the bank. Washington Mutual is no longer in existence, but the trust was never amended. The trust was
Right.
never changed. And it becomes a little more complicated because who owns the asset? But California courts only have jurisdiction over California assets and California property. So you got to go to Texas for some assets and so on and so forth.
I'm going to switch topics a little bit. And I have my one last question here is there's a lot of people who come to estate planners to do the planning where they want their mom or dad or grandma or grandpa to qualify for, it keeps changing, but Medicaid, for lack of a better definition, or for those listening, they want to get their parents or grandparents specific pricing on healthcare, because at the end of life, healthcare becomes very expensive and can drain all the assets completely out of somebody's estate. So there's different attorneys that specialize in these trusts that help to get them to qualify, like what I like to say, better pricing for their healthcare, and simple terms. So do you ever see problems with these trusts that there's just maybe people are listening and not know what I'm talking about or don't, but I'm just curious, like from a trust litigation standpoint, is there litigation problems with this happening?
I've seen, yes, unfortunately, I've seen it. I've seen problems where they're trying to get the aunt to qualify for Medi-Cal Medicare. And in doing so, I've seen people tricking elderly into signing over deeds to their house because the requirement they were told, the aunt was told, you can't have a house, you can't have that much in assets so to qualify for Medi-Cal in California and to qualify for additional benefits under Medicare. That's patently false and
Right.
it's incorrect. And in fact, last year, Medi-Cal switched over in California as an income-based, so income qualification. So if you have no income coming in, which if you're not earning Social Security or your Social Security is nominal, then you could potentially still qualify for Medi-Cal. And you're getting your Medicare benefits, you're getting your Medi-Cal benefits. But again, it's not going to a trusted advisor. It's not going to a proper estate planning attorney that is able to guide you on what the qualifications are. I see people do it all the time because either the family members are naive themselves, they don't understand, they trusted something that they read on Instagram or saw something on TikTok, and instead of going to a professional and looking it up, maybe because they don't have the resources to do that, they trust and they get rid of all their assets and they shift them over to another family member. But what that does is it actually hurts them, because as wonderful it is to have a safety net for people who cannot afford healthcare, it doesn't cover all the needs that someone has.
Right.
Like how Medicare is going to put you into a very low end housing, really low end facility for long-term care. And I look at it as if you have the means today to protect yourself, then get long-term care insurance. Put that money aside into different annuity and investment accounts with a financial planner to help you actually prepare and weather that storm that is inevitable.
Right. This was so fascinating, and I could probably keep going and ask you more questions, but I just wanted to, for those listening, everyone kind of understand that there's different attorneys that specialize in different areas of the law, and trust litigation is an important aspect since everybody knows someone that's gonna, and we all are eventually going to pass away. So I think a lot of people aren't informed about this. So it was really interesting, and I'm happy that I got to ask you these questions today. Is there anything else you'd like to tell us?
No, I'm just honored to be here. I mean, I look at it as I'm the last resort for when things go wrong or when there's problems, and I'm more of a fixer at the end, but I would rather someone spend that time, energy on getting proper financial planning and getting a really good estate plan and having the team of CPAs together to help them go through this process. The other thing I can say is my biggest advice to parents and grandparents is talk to your family. Tell them what is happening. Tell them what your estate planning plans are. People don't like to talk about death, but it is very important to forewarn and front load your children, because when you don't, they have expectations, and when those expectations aren't met, my door is being knocked on.
Right. I like how you said you're a fixer. I like that word. I would think so. If you're fixing it after the fact, then it happens. So thank you.
Awesome. Thank you so much.
If you've enjoyed today's episode, please consider subscribing to the Business Talk podcast and leaving us a review on your favorite podcast platform. Your feedback helps us grow and improve. Thank you for joining us today. This has been another episode of Business Talk with Meghan McNulty.